excited to do the presentation. So I'm just going to bring up my screen share now, so hopefully you can see the presentation that we're going to go through. There we are. So like Nisa said, my name is Eryn Jackson, and I'm a lawyer with Richards Buell Sutton. Our office actually has 2 locations. We have one in Vancouver and one, like Nisa said, in Surrey, the Guildford area, which is where I'm located. My practice is what we like to call a general solicitor practice. So I deal with wills and estates, which is what we're going to talk about today, as well as real estate and business corporate law. So I like to say that I deal with what the average Joe would need in their day-to-day lives, and I leave all the fighting and the unhappy law to other lawyers. So let's get started. We're going to chat about estate planning today. So when you think about estate planning, what is the first thing that comes to mind? A will, hopefully. Now, what happens if you don't have a will? So if you don't have a will, that's what we call intestacy. So essentially that means that the statute, the Wills, Estate and Succession Act, governs who receives your estate. So under that act, it essentially says it's your closest next of kin. So if you don't have a will, then if you have spouse and no children, everything goes to your spouse. If you have spouse and children, then your estate will be split between your spouse and children, depending on their relationship to each other. So if the children are from both yourself and your spouse, then your spouse gets the first $300,000, and the rest is split 50% to your spouse and 50% to your children. If your children are from a prior relationship, then your spouse will only get the first $150,000 of your estate, and the rest will be split 50% to your spouse and 50% among your children. If you don't have spouse or children, then we go down the tree to grandchildren. If you don't have any grandchildren, then we go back up your family tree to your parents. If your parents have predeceased you, then we go out the branches to your siblings. And if any of them have predeceased you, we go down to the nieces and nephews. And essentially we keep building our tree until we find the closest next of kin. And that's who would receive your estate. So if you don't want your closest next of kin to receive your estate, really important that you do a will, because a will is the only way that you can appoint someone else to be beneficiaries of your estate. Okay, so what is a will? A will is essentially a testamentary document in which you can govern what happens with your money and property after you die. In the will is where you would name your executor. So that's who's the person that gets to deal with all of your money and property after you die. Could be a friend, could be a family member, could be a trust company, completely up to you. In the will, you would also name beneficiaries. So beneficiaries are who gets the money and the property after you've passed away. So who benefits from the assets you've built up during your lifetime. It's also very important that if you have minor children, that you have a will to name guardians to care for your minor children. If something happens to you and you don't have a will, or you have a will that doesn't name a guardian for your minor children, then unfortunately, it means your children will have to go to social services until a family member or a friend can make a court application to be appointed as guardian of your minor children. So really important, even if you have no assets to include in a will, if you have minor children, do a will just so that you can name guardians to take care of your children should something happen to you. All right, now when we think of your will, we want to think about what's your estate. So what will the will deal with? So essentially, when you pass away, we don't know how big your estate's going to be. It could be really small, like this small estate here. It could be really big, like this big estate. Now, your will only deals with assets that fall into your estate, but you can have assets that pass outside your estate. So that would be out here in the big circle around our big estate. Now, it's not good to be outside the estate versus inside the estate. It's completely dependent on what's best for you. So assets that would pass outside your estate that your will would not deal with would be things such as real property, so land or homes that you own as joint tenants with someone. So that means Everyone entitled to the property owns the property equally 100% together, and you've got an automatic right of survivorship. So if something happens to one of you, the property automatically goes to the survivor, okay? Now with real property, you can have it registered as tenants in common. Tenants in common means each person on title owns a certain percent of the property, could be 50-50, could be 90-10, completely dependent on how you registered. And if something happens to one of the owners, their interest in the property goes to their estate for their will to deal with. So it's really important that you take a look at how you registered ownership of a property that you own with another person. Is there the right of survivorship? Does it pass outside of your estate? Or is it a tenants in common situation where your interest in the property will be part of your estate? Then we have bank accounts. And bank accounts that are registered as JWROS on title means they are joint with right of survivorship. So similar to the property, it means everyone that's registered on title to that bank account owns it equally 100% together. And you've got an automatic right of survivorship. So if something happens to one of you, the bank account goes to whoever lives the longest. So it passes outside your estate. Then we have life insurance policies. And where you've named a beneficiary directly on the life insurance policy, on proof of death, the insurance goes directly to that beneficiary. Your estate doesn't deal with anything. Next, we have RSPs, or if they've turned into RIFs, those would apply as well. So with RSPs, where you have a spouse named as beneficiary on the policy, on proof of death, the account can roll over to the spouse's account tax-free, no tax consequences, till they start drawing the funds out of the account. If you've named anyone other than your spouse as beneficiary on your RSP, such as children or maybe friends, then it's a deemed disposition upon death, which means your RSP is collapsed. The money goes to the beneficiary you've named, but your estate has to pay the taxes on it. So you want to keep that in mind when you're double checking who you've named as beneficiary on your RSP. Will there be a tax consequence? If so, do you have enough money falling into the estate to pay those taxes? If not, you may want to rename the beneficiary on your RSP to make it the estate so that the money from the RSP falls where the taxes fall. Then we have the tax-free savings account, TFSA. And again, where you've named a beneficiary directly on the policy, on proof of death, the money goes directly to the beneficiary you've named. No tax consequences because you've already paid the taxes on it, and your estate doesn't need to deal with anything regardless of who you've named as beneficiaries. Now, if you have registered education savings plans, maybe for children or grandchildren, you want to make sure that you've named a successor on the policy or someone similar to that. Essentially, who's going to step into your shoes and continue managing the policy for the benefit of the minors. If there is no successor or an equivalent named on the policy, then sometimes the RESP is treated the same as the RRSP in that it's a deemed disposition upon death. So the RESP would be collapsed. You'd have to pay back whatever government grants you've received, and the money would fall into your estate to be dealt with under your will. So it wouldn't necessarily go to the benefit of the minor that you've named on the policy. So really important that you check all of these different assets that you may have to see how you've registered them and who you've named as beneficiaries to try and take advantage of assets passing outside of your estate. Now, way over in the bottom corner here, we've got pensions. And that's because pensions are their own beast entirely. So by law, we can never designate a beneficiary for your pension through your will. And that's because the pensions have their own rules and regulations. So if you have a pension where you want to name a beneficiary or change a beneficiary, you have to deal directly with that pension company. So really important that you reach out and get that information to make sure you've organized all of your assets the way you want them to. Now, in a typical first marriage with joint children, your estates may look similar to this. So we've got mine, yours, and ours in the first picture there. And you'll see that the mine and the yours are fairly small. So that means you've got fairly small personal estates, not much in just your name, but you're probably pretty well off because you've got most out there in the ours section, the joint ownership, the named beneficiary, that sort of thing. Which means when the first of you passes away, the mine passes the spouse, the ours defaults to the joint owner, and that means it's not until the last of you passes away that then everything would fall into one big estate for your will to deal with. Now, not everyone's estates look like this. Not everyone's estates can avoid the need for dealing with a grant of probate or dealing with an estate when the first of you passes away. Just keep this in mind if you're trying to reduce probate fees or make it as easy and simple as possible, then you want to make sure that there's not much in your personal estate. Because under estate laws, if you have assets that add up to more than $25,000 in your personal name when you pass away, then unfortunately, you may be required to get a grant of probate in order for the survivor to be allowed to deal with those assets. So the key there is keep your personal value less than $25,000 all in, so you can minimize the need for dealing with an estate. Now, again, this doesn't work for everyone. When we have mixed families, you may not want your estate to look like this. You may want to make sure there's something that goes to your children. You may not want to give everything to spouse. So this is not a one fit all. Please, if you've got a personal situation you're not quite sure what to deal with, get advice before you do any documents to make sure that this fits your situation appropriately. Now, a lot of people think this works so well between spouses, having everything joint with spouse, that it just automatically passes to the survivor when you go. Why don't I do this with my kids? And that way I can avoid having to deal with probate altogether, and it'll just automatically go to the next generations. Well, unfortunately, joint assets aren't always a great idea with someone other than your spouse. So there are some risks associated with making people joint on your assets. The first is you're losing control of that asset. So that means if you decide you want to go on a big vacation and you want to use all of your money in your personal account, well, you can't take all that money out if there's a joint owner unless that joint owner agrees to that. Now, most likely your kids would never stop you from going on vacation, but I've seen sillier things happen. So just keep in mind, you lose control of the asset when you add someone joint on it. You're also opening your assets up to their liability risks. So if that joint person is going through a messy divorce, if they have creditors coming after them, your assets are now open to those claims because you've named this person joint on those assets. You also need to keep in mind that there is a potential that that joint owner could be open to claims from your beneficiaries. And that's because the courts have deemed that if an asset is not a true joint asset, so if when you put someone joint on your asset, your intention isn't that they get to use it all 100% for themselves however they'd like, at that point, if you're putting them on just to help you manage it, but the intention is the asset remains yours, then technically that joint owner is holding the asset in trust for you, which means they're also holding it in trust for your estate after you die. However, the banks don't understand this. So when asset is jointly held, the bank will say, well, it automatically goes to the survivor, so they get the bank account, which means the joint owner is now at risk of claims from the beneficiaries of your estate saying, wait a minute, you've stolen an asset that should have been an estate asset. So it can get a little complicated and messy for sure. Now, in particular with property, real property, land or homes, if you add someone joint on title to the property in order to avoid probate, but the other joint owner isn't actually living in the property, then you're actually triggering capital gains tax. And capital gains tax can be much more expensive than probate fees. Capital gains tax typically works out to being 25%, whereas probate fees are 1.4%. So definitely get advice not only from a lawyer, but from an accountant before you go making your assets joint with someone that's not going to be a true joint owner. So they aren't going to be contributing and benefiting equally to these assets. Then you need to make sure you get proper advice to make sure you're not putting yourself and the other joint owner at risk. All right. Now we're down to the executor's role. So essentially, the executor's role is twofold. First, they are your executor, then they become the trustee of your estate. So as executor, their job is to dispose of your body, clean out the fridge, check the insurance, and put everything on pause. Once they've done that job, they then become the trustee. And as trustee, their job is to figure out what assets you have that actually fall into your estate, gather them up, and distribute them based on your will. So if we think about this big box in front of us as your estate, whatever's in just your personal name when you pass away falls into this big box. And from those assets, your executor has to first pay out any debts you may have, so mortgages, line of credits, that sort of thing. Then we have the cost of funeral expenses if you haven't already prepaid for something. We then have the cost of executor fees, and I'll come back to that one. Then they have to pay whatever income tax that you may owe and any extra expenses in regards to dealing with your estate. And it's not until all of those are paid off the top that then whatever we're left with is called the residue. And the residue is what you can divide as many ways as you like between the beneficiaries of your estate. So that's what they actually receive after you pass away. Now, to do the job of executor, they can charge a fee, and that fee is up to 5% the value of your estate, regardless of the size of the estate. It's completely dependent on the amount of work that needs to be done. So if there is a house they need to clean up and sell, a car they need to sell, maybe even a business they need to wrap up, that's going to be a lot more work than if it's just a little old lady in an old folks home with one bank account. So our executor has to keep track of the time that they're putting in order to justify the fee that they're charging. Most charge between 2 and 3.5%, but honestly, that's not something you need to decide now. Wait till they actually take the job on and see how much work it is. Now, the fee is considered income, which means they have to pay tax on the fee. To be fair, they're being paid to do a job, so they should pay tax on it. But at the same time, all of the beneficiaries of your estate have to approve the executor's fee. So that's going to keep your executor on side from charging the highest amount if really they've done the least amount of work. Although, to be quite honest, most beneficiaries are so happy they didn't have to do the job and someone else did, they don't normally argue those fees. Now, with the taxes, there's a lot of ideas that there are death taxes when you go, and that's not the case. There's no special taxes, no special rates. So it's the same old income tax you'd pay, capital gains you'd be responsible for, or principal residence exemption you'd have eligibility for. So there's no special taxes, no special rates. Your estate may be in a slightly higher tax bracket because now you've got more falling into it than you regularly would have in a year, but there's no death taxes, which also means that anything your beneficiaries receive, they receive tax-free because your estate has already paid the tax before they receive their gift. So there's no inheritance tax in BC either, at least not yet, and fingers crossed they don't change that rule anytime soon. Now, you do need to keep in mind that if you are naming a beneficiary that is not a Canadian resident, they may have inheritance tax in their jurisdiction. So all we can do is protect in BC We can't guarantee that the beneficiaries in a different jurisdiction may not have separate rules and regulations in their location. Same thing with the role of executor. We always advise that it would be best to name a Canadian resident as an executor, because if your executor is not a Canadian resident, if they're a resident of the US or a different country, then there's a chance that your estate may become a non-resident estate, which means it'll be taxed and governed based on the jurisdiction of where your executor is located. So really important is to make sure you've got a Canadian executor. That makes your estate much easier to deal with and reduces the tax consequences. And just notify any beneficiaries you have who are not Canadian residents that they should check with their jurisdiction as to whether or not there are inheritance taxes for them. All right, so we've covered the role of executor. Now let's talk about our beneficiaries. Now it's really important when you think about beneficiaries, don't just think about the first step. Think about what if, then who. And that way your will be able to cover a various number of situations that may happen without you having to update your will anytime life throws you a curveball. So again, I'm going to show a typical family. So in most husband, wife, and joint children situations, spouses say in their will, well, first I want everything to go to my spouse. If not, then I want equally among my children. Now, don't stop there. Like I said, think of the what if. So you want to think, okay, if something happens to one of my children before me and they have children, would I want their share to go to their children, my grandchildren, or would I want their share to go to their surviving sibling? So depending on how you structure your will, you could provide for next generation, or you could keep it with first generation. Completely up to you. It's whatever you prefer. However, this needs to be kept in mind that there are potential claim risks. So unfortunately, in BC, and BC is one of the only provinces that does this, they allow spouses and children to make a claim against your estate if they haven't received or haven't received enough. Now, that doesn't mean that you have to include them or have to include them equally. It just means that if you are purposely excluding someone or giving them a smaller share, it would be really important for you to do a document that we call a statutory declaration. And essentially that's where you would explain why you're making the will the way you are. So it's not, I'm leaving my spouse out because I forgot I had another spouse. It's, we came together later in life. We both had our own assets. We have our own families. We agreed to keep our assets separate because we wanted to provide for our own families, that sort of thing. Now, you need to be aware that the claim from children is restricted to biological or adopted children. So stepchildren have absolutely no right to make a claim against their step parent. So keep this in mind if you've got a bit of a unique situation where maybe you've lost contact with one of your children and you don't think they deserve to receive a share, or you've got a mixed marriage situation where you do want to ensure that your children receive something and that everything doesn't all go to your spouse. It'd be really important to protect your estate to do this declaration explaining why you're making your will more unique. Now, unfortunately, the statutory declaration does not stop someone from making a claim. Unfortunately, you can never stop someone from making a claim. All we can do is try to protect against them being successful with their claim. So that's what the statutory declaration would do. It's essentially you speaking from the grave, which is going to be the best protection for your estate and your will, because the courts are very reluctant to change your will, change your testamentary intention if you're not there. So really important that you're able to express your wishes through this declaration to protect any potential estate claims. All right, so a lot of people think, well, if there's a potential of claims, I want to avoid claims. I want to avoid going through probate. So there are a number of ways that you can try to avoid assets being part of your estate, reduce the probate amounts that you would have to pay. But again, it's up to you whether or not it's appropriate for your situation. So again, you can name beneficiaries directly on assets like we talked about earlier. So naming beneficiaries on your life insurance, on your RSPs, your TFSAs, on your pensions, those assets would pass outside your estate directly to the beneficiaries. No one has a right to make a claim against those assets through your estate. Also, making assets true joint assets is another way to reduce probate fees and remove the asset from estate claim possibilities. If your home is jointly held with your spouse, it means it automatically passes to whichever one of you lives the longest. Your children would have no right to make a claim against that property if you pass away because it automatically passes to your spouse. It's not part of the estate. Same thing with joint bank accounts, but keep in mind they have to be true joint assets. So you can't just add someone on title to try and avoid probate if the intention isn't that as soon as you add them on to the property or the asset, that they get equal right to use and abuse, okay? You can also give gifts during life. No one can stop you from making gifts of your assets while you are living. Anything you gift during life is not part of your estate because it's gone when you pass away. Now, the fourth option here is trusts. And trusts are a little bit more complex and convoluted, but they can work really well in some situations. So trusts are essentially when you set up a separate entity that holds the assets for your benefit, and the trust is actually a tool that you can govern who receives it after you pass away. So it's almost an alternative to your will. So if assets are in your trust, they do not form part of your estate. Your will does not deal with them, which means there are no probate fees associated with those assets because they don't pass through your estate. And there are no estate claims that can be made against those assets because, again, they are not part of your estate. Now, there are different types of trusts. A trust through your will, which would be an important tool to use if you have minor beneficiaries or beneficiaries who are disabled and cannot handle funds themselves, would be called a testamentary trust. So a testamentary trust does not avoid probate. It just protects the asset for the minor or the disabled beneficiary. So testamentary trust would not be the type of trust you would use if you're trying to avoid probate or estate claims. What you would want to use is called an inter vivos trust. So essentially that's a living trust. Inter vivos, during life, testamentary, last will and testament, after death. So inter vivos trust, there are two essential trusts that we deal with mainly. That's called the alter ego trust and the joint partner trusts. So with these trusts, essentially they are created during your lifetime and allow you to have assets pass outside of your estate, not through your will. Now, in order to set up these trusts, you have to be over 65 in order to qualify for the special tax treatments. If you're under 65, unfortunately, you do not qualify to set up these types of trusts. Now, alter ego is essentially saying, I'm creating a trust just for myself. So I will be the trustee, I'll manage the money in the trust, and I will be the main beneficiary while I'm alive. So I'm the only one that can benefit from these assets in my alter ego trust. Conversely, joint partner trust would be a trust that you would set up with your partner, your spouse. So that's where you say, we will be the trustees, we'll manage the money for ourselves, and we will benefit from the assets while we're still alive. Now, with both of these trusts, you need to make sure that you are the only ones to benefit from your assets while you're alive. It's not until after you pass away that then you can appoint secondary beneficiaries. So that's who receives it after you and your spouse are no longer around. Now, again, having the assets in these trusts avoids probate fees and avoids will claims, because again, they pass through the trust. The trust is a separate entity. No one can make a claim about it. It's not part of your estate. So it is a great way to protect assets. However, trusts can be expensive because not only do you have the cost to initially set up the trust and transfer the assets into the trust, but you also have to file annual returns for that trust. And anytime the trust does something, there has to be documentation authorizing the trust to do it. So there are ongoing expenses associated with a trust. Same thing with the taxes. So you get the tax benefits provided you are over 65 when you set up these trusts. But once you pass away, your trust is taxed at the highest marginal rate, which means you may get a better tax treatment if you just let the assets pass through your estate. So really important that you don't just go setting up a trust yourself. Get advice from an accountant, get advice from a lawyer to make sure that this trust will make sense for you and it won't cost more than it's worth. All right, so we've talked about the estate and we've talked about the will, but I want to talk about all estate planning with you today. So we're going to take a look at this lifeline, and I'm going to pretend that the horizontal line there is your lifeline. So it's not until after you pass away, so after death, that you have a will to deal with your money and your property. Now, everyone in life has four main decisions they deal with: money, property, personal, and medical. Well, after you die, there is no personal or medical. It is just money and the property. So that's what your executor deals with under your will. But we want to deal with, what about when you're alive and well, and maybe you just need help, or maybe you're alive, but you're not doing well and you really need help. Well, who can help us with these issues? So again, four main things we deal with: money, property, personal, and medical. So who helps you with your bank accounts, with your investments? If you need to refinance your house and you've broken your arm, who can help you with signing the documents for the refinance? If you're incapacitated and you can't decide what to dress, how to eat, where to live, who deals with that? Who's going to take care of those personal decisions for me? If I'm in hospital and I can't tell the doctor yes and no to treatments, who's going to help me with these things? How do they help me? So these are all really important questions and things that you need to consider to make sure that you are properly protected no matter what situation arises during your lifetime. So the first one we're going to talk about is power of attorney. So again, the will deals with money and property when you've passed away and you're no longer able to deal with it. But what about when you're alive and well and you just need help with that money and property? That's what the power of attorney is for. So that's where you can name an attorney, someone you trust, to help you with your money and property. Now, at all times, you're in charge. You tell that attorney what you want them to do. They carry it out for you. If you die, power of attorney is revoked because you can't tell them what to do anymore. That's fine, because that's when your will kicks in and the executor starts their job. Now, having said that, should you lose capacity, to deal with your money and property, technically the power of attorney should be revoked as well. Because again, you can't tell them what to do. But what we've been allowed to do over the last couple years is add a clause into the power of attorney document that says, if I lose capacity to deal with my money and property, I want my attorney to continue to be able to act for me, which means you're covered now when you're alive and well and you just need help. So maybe you've broken your leg and you can't get to the bank, your attorney can go to the bank for you. But it also covers you after you've lost the capacity to deal with money and property. So car accident, stroke, Alzheimer's, anything like that. Now at all times, your attorneys can only deal with money and property. So they can't talk to your doctor and they can't put you in the hospital. So that leaves us with the other two decisions, the personal and medical decisions, which is what we have a healthcare representation agreement. And this is where you can name a representative, again, someone you trust, to assist you with personal and medical decisions. Again, as long as you've got capacity, you are in charge, you tell that representative what you want them to do, they carry it out for you. So if maybe you're just too sick and tired to talk to the doctor, but you know exactly what you want to tell the doctor, you would give this document to your representative, say, this is what I want you to tell the doctor, and the representative will go talk to the doctor on your behalf. So essentially, this allows them to be your spokesperson or your advocate. It's only if you've lost the capacity to deal with personal and medical decisions, which through our documents, we say it's when one doctor and one lawyer have put in writing that you're not making safe decisions anymore, that then your representative would be in charge of those decisions for you. But they have to continue making those decisions based on your stated wish. So they can't change the game plan if they're in charge. Now, most clients come to see me because they want to do their will, because they think that's a responsible thing to do. And it absolutely is. I would not deter you from that. But they find the power of attorney document ends up being the most cost-efficient document for the period when they've lost the ability to deal with their finances. Yet the healthcare is the one that matters most to people because it's the most personal. It's who's going to know what type of community I want to live in, or who's going to notice if I need a new pair of slippers, something like that. Now, if anything happens to you that pushes you over the edge and you lose the capacity to deal with any of these decisions, money, property, personal, or medical, unfortunately, no one has the ability to make those decisions for you if you haven't done the power of attorney or the healthcare representation agreement. So essentially, it means that the public guardian and trustee would most likely step into the situation to make sure that you're not being taken advantage of. And then a substitute decision maker would be put in place, most likely the BC public guardian and trustee, to say, we'll make interim decisions for you while you're not capable. Now, if you don't want the public guardian or trustee to make those decisions, then the only way someone else, family member or trusted person, would be able to make those decisions on your behalf, again, if you haven't done the power of attorney or the healthcare representation agreement, is if your friends and family make an application to court, public guardian and trustee gets involved to say, yes, we approve of this application. Two doctors have to do an assessment to make sure you don't have the ability to deal with any of these decisions anymore, money, property, personal, or medical, before the court will appoint someone as your committee to make those decisions for you. And that can take 3 to 4 months, although more recently I've been seeing them take closer to 5 to 6 months. And they can cost anywhere from $6,000 to $7,000, although if it is a difficult application, it can take anywhere upwards of $10,000. So really important that if you want to say as to who makes these decisions for you, if you're not capable, that you do a power of attorney document and you do a healthcare representation agreement so that you've got people you trust to make these decisions for you. Otherwise, it's up to the court who gets appointed, And by that point, you've lost capacity, so it's too late for you to have a say. So this is a real quick synopsis of quite a bit of information, but we've made it to the end. So I'm going to open it up to questions. And just before we start questions, I do have to disclose that I'm a lawyer. Disclaimer, all of this information is purely for information. It's not giving you legal advice. So please, before you do your own documents, get assistance, get advice from a lawyer, from an accountant to make sure that the documents you are doing reflects your personal situation, okay? So information purposes only, not giving you legal advice because I don't know your personal situations. All right, questions? Nisa, do we have any questions in the chat box, or are we gonna unmute everyone?
So there aren't any questions in the chat box yet, but if anybody wants to unmute or pop a question in the chat box, please go ahead.
I'll ask a question.
Sure.
What is a procedure for a person who was born out of wedlock or prior to being married in claims against a father's estate who did not marry the mother?
So it doesn't matter if your parents were married or not, it's biological. So if they're listed on your birth certificate, you are their biological child, which means you have a right to make a claim against their estate. Now, if they were adopted out by someone else, then that relationship has been severed. Does that help?
So if that person you say was adopted by the mother's husband, then that severs the blood relationship?
Yeah, typically it severs the relationship with the biological if they've been adopted by the new. However, I have seen situations where the biological tie is still maintained and the adoption is an additional tie. So now that child has a right to claim against all three, biological mom and dad and adopted father. So it depends on the certain situation and what type of adoption was done.
Okay, that's very interesting. What about where we have a small company, and how do you protect yourself against a claim from that company or your partner in the company for outstanding debt or something that the company has?
So typically a company is a separate entity. So the company is responsible for its own debts, and it can't go past the company to the shareholders to claim debts. So there's sort of protection for shareholders as long as the shareholders haven't mismanaged or done anything illegal or fraudulent to warrant a claim being against them. Now, with companies, typically they are limited liability, which means there is a limited liability risk for the directors of the company. And essentially, directors are the ones that manage the day-to-day operations of the company. So they're the ones that tell the company what to do, which means if the company fails to collect or remit GST, PST, workers' compensations, or deductions from workers' wages, then the directors could be held personally responsible in those situations for essentially telling the company to rob Peter to pay Paul. So other than that, there shouldn't be a reason that a claim against the company can get past the company's assets and claim your personal assets. Now, if it is a family law claim and spouse is part of the company, then yes, everything's on the table, it's fair game. But third third-party claims should be restricted to what the company owns, unless, of course, there was something fraudulent or illegal done.
Okay. I'll let somebody else have a chance to speak.
There's a couple questions in the chat. The first one is, what is the personal part of the representation agreement?
So personal is essentially, where do you live? What do you eat? How do you dress? Who do you talk to? It's anything to do with your personal affairs. So again, if you do the representation agreement now and you've got the capacity to make all these decisions yourself, that's great. It means your representative doesn't have to step in to make these decisions for you. And just because they do step in doesn't mean you can never then take control again. So a representation agreement can fluctuate depending on your situation, your capacity, as to whether or not the representative would be in control or whether they'd just follow your instructions and they carry out your wishes. But essentially it covers everything about your personal and medical affairs, okay? So really important that you trust the person you're appointing.
And then you said that it's one doctor and one lawyer that decides whether that rep agreement needs to go into play?
So it would be one doctor and one lawyer through our document. Other firms draft it differently because it's not required that way. But we feel this is the safest way for you to feel comfortable appointing this person without feeling like they can overrule your decision at any point. So one doctor and one lawyer would have to put in writing that you no longer have capacity to make safe personal and medical decisions anymore before your representative can take control of those decisions. So it doesn't mean that your representative can't help you before that point. They can absolutely help you if you ask them to and you give them the document. They can be your spokesperson, but it's only if the doctor and lawyer have said, you're not making safe decisions anymore, that then the representative would be in control of those decisions.
But it is possible that once that rep agreement is in place, there could be a decision made that let's revoke that, at least temporarily, because things have improved or whatever, that you don't have to legally be the rep.
Absolutely. I mean, just because you're appointed as a representative doesn't mean you have to do the job. You can always renounce doing that job. And just because you're appointed doesn't mean you have to act right away. So I've got a representation agreement where I've appointed my husband. He's not doing anything right now because I'm still capable of acting, yet he's still appointed as my representative. So if I go into the hospital and I have a surgery and I'm going to be temporarily incapacitated, it means he has the right to speak to the doctor on my behalf. But once I'm awake and feeling better again, I'm in charge. So as long as you've got capacity, even if it fluctuates, it means they can assist you. They just don't have the ability to overrule your decisions unless the lawyer and doctor have put in writing that you're not making safe decisions. So that mainly comes into play in a situation where you're probably still living at home and you've lost capacity and maybe you're doing dangerous things like leaving the stove on, walking away, forgetting about it, that sort of thing. And in that case, your family may be saying, well, we need to move you into assisted living. We need to bring in full-time care to make sure that you are being safe and protected. And you're refusing. You're saying, no, absolutely not. I don't want anyone coming into my home. I don't want to move. The only way your family can overrule your refusals is if the lawyer and doctor have put in writing that you're not making safe decisions for your personal matters anymore. So that's really the only situations that the overruling comes into play. Otherwise, your representative is basically your spokesperson, your advocate. They step in when you need them to, but they don't take control if you don't want them to.
Thank you.
You're welcome. I know that's a tough one to wrap your head around, but I can give you a quick example that I ended up using a representation agreement in my personal life, and it made a world of difference. So a couple of years ago, my dad got really sick and he was in the hospital. And because of his illness, he was on pain medications, recurring pain medications. So every couple hours, the nurse would come in and give him a dose of pain medication. So this one day, the nurse came in, gave him his next dose, and then they left. Their shift was over. 5 minutes later, another nurse came in and said, oh, time for your pain medication. And my dad, my mom, all of us children were there. And we all said, no, 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 he just had his medication. We saw the other nurse give it to him. And the nurse said, well, it's not on his chart. And because he can still speak, I need his refusal for the medication. So of course, the nurse says to my dad, how are you feeling? Are you in pain? Would you like some medication? And by then my dad was as high as a kite. So he says, yeah, sure, give me some more. So unfortunately, we had to barricade the door to my dad's hospital room until my mom could go home, get the healthcare representation agreement that my dad had appointed her on, bring it back to the hospital so that we could show the nurse that we had been given authority to speak on our dad's behalf, even if he had capacity according to them. Now, if they had asked him a couple more questions to see if he did have capacity, they would know he didn't, because we asked him, where is he? And he said he was in Regina when he was actually down in Peace Arch. So he was not capable of making safe decisions at that point. And if we didn't have the healthcare representation agreement, we would have had no way to protect him from being overdosed. So it's a really important document, comes into play when you least expect it. Okay, there's another question in the chat. For your representation agreement, if you don't have family, friends, or anyone who can become your rep for personal health care decisions, how do you find someone who can take over this responsibility? Unfortunately, I don't really have an answer for that one. I've been hunting and hunting and hunting to see if there's some sort of program that is available. I know the public guardian and trustees sometimes will step in for these decisions, but unfortunately it depends on your assets. So if you don't have much assets, if they can't guarantee that they'll get paid, they may not step in. There have been a couple programs out there that you can sign up for that will allow you to appoint someone as a representative, and it's basically their job to be your advocate. But again, they're costly. So a lot of the time people don't qualify or can't afford those different programs. So unfortunately, I don't have an answer. If you've got friends with younger kids who might be willing to do it, nieces or nephews, even neighbors or pastors, we've seen lots of different people in different situations being appointed. Sometimes an accountant is willing to do the job, or financial advisors. Some notaries will occasionally be appointed. Not many lawyers have the ability to be appointed because it sort of conflicts with their obligations through the Law Society.
I would like to go back to the question before this one. I have a husband that came home from the hospital. He has now assigned, what do you say, advocate? Somebody that if I'm not able to be there, he steps in.
Okay.
My feelings to that is I know my husband more than the person that he assigned. I know what, let's say, his feelings and all that. Well, this person steps in and thinks that I shouldn't say know everything, but know of his health better than me. And that's what I would like to know is, should I allow him to step in? Like my husband assigned him to be his advocate.
Unfortunately, you don't have the ability to change your husband's appointments. If you think this person isn't doing a good job, you can definitely report it to the public guardian and trustee, or you can try making a court application to be appointed as committee. But if your husband still has capacity to make his own decisions,
yes,
then
he is.
it's up to him who he appoints. So it might be worth having a conversation with your spouse to say, listen, I would really like to be appointed.
Well, I'm a power attorney right now. I'm a power attorney to my husband.
Yeah,
And this person thought that if I got, we'll say injured or whatever, not able to look after my husband, that my husband says, yes, I would like this other person to take over.
so that sounds like
Including-
they're an alternate, they're a backup.
That's what he was, but I would like to be the first one to say, yes, he should have this medicine. No, I don't think he should have this medicine.
Yeah, so
me,
your
he
husband
is-
should do a representation agreement. And in the representation agreement, he can appoint you as the first representative and this other person as the alternate representative, so the backup. But again, your husband's the only one who can do that. You can't do it for him.
So why do I have a power attorney if this other person that he assigned can overrule me?
No, so power of attorney and representation agreement are two separate documents dealing with separate decision-making. So
Okay,
power of
thank you.
attorney means you can deal with money and property matters. The representation agreement is who gets to deal with personal and medical matters. So if you want to talk to the doctor, you need to be appointed as his representative. A power of attorney means you can only deal with his money and property. You can't talk to the doctor.
Okay, thank you, lawyer.
You're welcome. I've got a hand up from Kenneth.
Yeah, I was, can you hear me? Yeah.
Yep.
Okay, I was wondering what happens when the executor quits due to the situation becoming too complicated or too legally involving.
Yeah, so if an executor has already intermeddled, so essentially started doing the job of executor, they don't have the luxury of just quitting the job. They have to be released from the job by the court. So it means they have to make an application to the court to be removed as the executor. If they are successfully removed, then typically the alternate executor, so the backup that you name in your will, would be the next one to step in. If there is no alternate, then most likely the court won't release your executor unless someone else is making an application to be appointed as the new executor. So it's a bit of a tricky situation and it's not an easy one to get out of. So if you are going to take on the role of executor, make sure it's something you're willing to do, because it's a big to-do to be removed. And when you're doing your will, really important that you do name alternates, backups. You want to make sure that you're covering your estate for any sort of situation that may occur with the least risk of having to do more court applications for someone else to be appointed. Now, if something happens to your executor and they die when they're in the middle of doing the job, again, then it means your backup would step in if they're willing. If they're not willing, or if you don't have a backup named, then unfortunately it's the executor of your executor who's died that takes over your estate administration. It's called chain of executorship. So it means you may end up having a stranger dealing with your estate if you haven't done proper planning yourself to make sure you've got the right people in place and enough people in place to cover those what if situations. Does that answer your question, Kenneth?
That's an interesting one. What happens if the executor is not the spouse and the spouse is still living?
If the spouse isn't named as executor in your document, they have no right.
They have no
You
say.
can make a court application to be appointed, but they don't have the right to automatically do the role.
I see. Okay.
Yeah.
Yeah. What happens when banks make mistakes and it gets into a legal battle between the estates and the executor trying to settle this? Is that that gets into a bunch of getting a bunch of lawyers together, I guess, is it?
Yeah, so I'm not quite sure what you mean by banks making mistakes. If you're talking about the joint bank accounts and it not being a true joint bank account, but the bank causes an issue by giving it,
Yeah.
then it does end up being an estate
Yep.
litigation situation where we have to make an application against that joint owner to say that asset should be part of the estate. Most estates that I've dealt with, once we explain the situation and the risk of claim against the joint owner, they typically say, yes, okay, it's an estate asset, and we just include it. We don't need to make an application. But if they are fighting it, if they refuse, then it's up to the beneficiaries and the executor if they think it's worth making a claim to get that asset as part of the estate.
Does an executor have within their expenses the ability to hire a lawyer to advise them?
Yes, absolutely. That's part of the estate expenses. Yeah.
Okay. Maybe that's probably what you have to do when you're not a lawyer yourself and having to battle with some other large
Yeah.
corporations or lawyers.
Absolutely. To be honest, with most estates, I suggest, even if it's not going to be a difficult one, even if it's not going to be disputed, or if it's small, it's always easiest to get professionals to guide you through the process. So get a lawyer, get a proper accountant so they can make sure that you're covering all the bases and ticking all the right boxes so that you're limiting any liability exposure as executor to yourself. Because if the executor does anything wrong, improper, they can be held personally responsible for any loss that the beneficiaries sustain. So it's always worth it to the beneficiaries to get the help they need to make sure they're doing the job properly and as safely as possible for themselves.
Now, it was an experience of a friend of mine that it got very, very complicated. It was supposedly going to be a simple estate, being the executor. And due to a mistake by a bank that was involved with the properties and a trust that was an endowment going to another group, that it got very, very stressful and very complicated.
Oh no, well, I'm sorry to hear that. I hope you made it through okay.
Survived, but with a lot of trauma.
Yeah, I'm so sorry to hear that. Unfortunately, with all these claim abilities, BC has increased their estate claims tenfold. So it's just meant that everyone's now fighting over money, which is unfortunate, but it's true. Money makes people crazy. And so if they think they can get an extra dime, they'll fight tooth and nail for it. So doing the best you can to prevent those claims is going to make it as easy as possible for your executor to deal with your estate.
In this case, it was the trust, there was the beneficiary organization that was going to battle against him. And yet there was a mistake that was causing the problem by a bank.
Yeah, we've seen a lot of charities take hardline approaches to estate planning and estates. So if you've got a charity named, very cautious because they take a hardline approach and they don't allow anything to get past them because it's all free money to them. So it doesn't hurt them to make life difficult for your executor.
Is there any training program for executors for people to prepare themselves
well, that's a good question. I don't know. I don't know if there is any program out there for executors. As far as I'm aware, getting a good lawyer and getting a good accountant that know how to deal with estates is going to be their best option because they'll basically guide you through the process and make sure that you're doing it as best you can despite all the hiccups that may arise.
What's your recommendation on how to choose an executor?
So what I normally suggest is don't ask the person to do the job because it's honestly not a job anyone can agree to right now. We have no idea when you're going to pass away and when the job is going to be available. So instead, I normally suggest just name someone that you think knows how to get the right assistance and can handle the physical capacity of it. They don't need to know how to do the job. They just need to be able to physically do the tasks that they're told to do. But honestly, I just say, name them and then apologize. say, so sorry, I hope you don't mind, but I've named you as, and letting them know that they can get all that help from the lawyers and the accountants and that they can charge a fee for doing the job normally makes it a little bit easier for them to be willing to do the job. However, really important to keep in mind, the person that you're naming, keep in mind their age. If you're naming someone the same age as you, the chances of them being able or willing to do the job by the time you pass away may be slim. So you might want to name a next generation so that you've got someone who is capable of doing the job by the time you go.
That's what I was wondering about too, so you answered that one. Thank you.
Good, I'm glad.
The person that you name as executor and don't tell them, they have the right to refuse to be,
Yes,
to
they
actually
do.
accept the executor role. Well, then what do you do when you're in that dilemma? It's too late, you're gone. The person's refused. What are you going to do if you don't actually
Yeah.
name someone that has agreed to it in advance?
But
I
if they
really
agree
wonder.
to it in advance and by the time you pass away, they've got their own health concerns, they can still refuse. So that's why we always say, regardless of whether you ask them or not, make sure you name backups so that if the one decides not to do the job at that time, you've got someone else lined up.
Now, do you have to
Is
have
that a fair answer?
do you have to have an agreement with the executor?
No, having an agreement with them will not do any help because they're agreeing when you talk to them 10 years before you die. So by the time you die, the agreement will be useless because you can't hold them to it. Does that help answer the question? You're always welcome to ask them if they're willing to do the job. Just keep in mind, even if they say yes now, they may not be able to by the time you pass away. So always name more than one, name backups so that you've got someone ready to go just in case the first can't.
Yeah. But it does behoove you to keep in touch with the person you've named who has agreed to do it. And even if they don't get that they've aged, that they're really no longer going to be capable, you can approach somebody else. You don't just, it's not a one-time thing and then hope that it works when you're gone.
Yep, you've hit the nail on the head right there. Wills, estate planning documents, none of these are written in stone. These are fluctuating documents. So you're going to want to make sure that you either stay in touch with the people that you're appointing, or if you don't stay in touch with them, update your documents as life changes. If the person you've named has been gone and you haven't talked to them for 10 years because you had a falling out, good time to update your document, name someone else that is in your life now. So you've got that right on the nose. Thank you.
But do you always have to, the person that ends up becoming your executor, do they have to be named like in your will or some other legal document to actually take over as executor? Because if it doesn't work out, what's in
your will?
Pardon me?
If they're not named in your will, they cannot take on the role of executor unless they're court appointed to do so. So they have to be named in your will.
So then if the person refuses and now another person has to be sought, and let's say you don't have a bunch of alternatives or whatever, then you have to go the court route and say, this person would make an ideal executor because, and then the court has to approve it before any of this can proceed?
Yeah, if you've only named one executor, or if all your executors say, no, thank you, not willing to do the job when you pass away, then someone has to make an application to court to be court appointed as your executor. Technically, it's as your administrator to administer your estate in accordance with your will. Now, I normally suggest name one of your beneficiaries as one of your backup executors because it's in their best interest to wrap up the estate so that they can receive their inheritance, right? So that's sort of my suggestion as a fallback as a potential executor. Even if you don't want them to be the first, toss them in as a second or a third, and that way, most likely, they're going to do the job at the end of the day. Okay, it looks like we've got another message in the chat. Are we covering the DNR? Yes, absolutely. I can cover the DNR. So DNR, for those who aren't aware, is a do not resuscitate order. And typically this is something that you would sign with your doctor if you're going in for a big surgery, or if you've been admitted to the hospital and there are concerns, they'll make you sign a do not resuscitate. A do not resuscitate is technically not a legally recognized document, similar to what we call a living will or an advance directive. Those aren't legally recognized documents in BC. Essentially, what those documents do is they say yes and no to certain things at a certain point in time. So the concern with all of those documents, the living wills, the advance directives, the do not resuscitates, is that they end up having gray areas. So a situation where it may not be clear, does this apply, does this not apply? If you've said no to a ventilator, thinking you never want to be on a ventilator for the rest of your life, and then you end up getting COVID and going to the hospital and they say, we need to put you on a ventilator for 5 days and then you'll be fine. Well, if you're not able to tell the doctor, yes, okay, do it, then if you've signed this advance directive saying no ventilator, the doctor can't give you the ventilator. So what we found is those documents are so potentially narrowing that they could leave you in some precarious situations. So that's why they've created the healthcare representation agreement. And that document actually goes above and beyond the do not resuscitate, the advance directive, the living will. And it says, if I can't be the one to tell you yes and no to these treatments, then the representative, the person I've named in this document, is who I trust to make the call at that time. Now, that's not to say don't do a do not resuscitate or an advance directive or a living will, but if you do those documents, they're more of a supplemental, a guidance for your representative. The representative is a bigger one. It means you trust this person to make the call depending on the circumstances, advancements in medical technology. Is this what you meant when you did the document? Or did you mean it more in a broad general suggestion? So it leaves the flexibility with the representative so that you can be covered for those gray areas you may not have considered. Does that make sense?
In theory, it does, but the experience I had with my father, he's 87 years old now, and about, I don't know, year and a half, I bring him home from emergency and he says, oh, here's a form. And I look at it and I had just learned somewhat about the do not resuscitate form. And I was shocked that he handed me this form. And the first part of it says, this was done at Surrey Memorial Emergency. The first part of the form says, do not resuscitate me. If I have a heart attack, basically, don't try to, prolong my life. And he had indicated that. And at the time, I was not sure if that is what he meant. He has English as a second language challenges. And I did not know, in a busy environment like emergency, was it really explained to him what he was answering? And so I went and found out some more information. And then I came back to him and I said, Dad, do you realize what you indicated? And in his case, yes, he does not want them to resuscitate him. He's already had one heart attack and he's not willing to, have any tubes down his throat, et cetera, et cetera. But if you don't, and if you indicate at the very beginning, I don't want you to resuscitate me, then the rest of the form talks about what you talked about do you want any intubation? Do you want this? Do you want that? Various things that would prolong your life possibly in emergency. So in his case, pretty simple. Hey, don't resuscitate me. But my question is, and I don't think I could actually, I never got an answer to this. This form was filled out by a doctor. It had to be signed and dated and all that in emergency. Now, because my father has gone to emergency more than once because of his health condition, does that document stay on file in the emergency system and possibly the rest of the hospital, so that should he end up in a life and death situation, do they refer to the latest DNR form And I was surprised that you mentioned you can actually go to your doctor to get this done. This is the first I've heard of it. Now, what
Yeah.
if you go to your doctor and you fill out that form differently than the last time you were in emergency and they filled this thing out? How
Yeah.
are they going to know that there is a new form? And if the last one they got is "don't resuscitate me," but you've now changed it at your doctor's office and says, "Oh yeah, I think it's okay. Like don't make it that stark of a response." How does anybody know? Oh, sorry, he didn't survive because we didn't know he changed it at his doctor's office. Like, this sounds very
Absolutely. And you are bringing up all of the gray areas that we are concerned about, which is why the representation agreement came about. So the issue in BC, and I can't say this for sure because I am not in the medical professional industry, but my understanding is that what you do at your doctor and what they do at the hospital don't overlap. So the hospital doesn't have your personal records from your family doctor. What you do with your family doctor doesn't go with you when you go to the hospital. Same thing if you've done something in one section of the hospital, it doesn't necessarily transfer to a different section or to a different hospital. So you could end up having multiple documents, like you've said, that say differing things, which could cause a lot of concern depending on where you are and what your actual expectations are at that time. So that's why I'm suggesting the healthcare representation agreement, because that's saying that I trust this person who knows me to make that call at that time if there's any gray situations that the doctors aren't sure of. So if the doctors find two different do not resuscitates and they're not sure what to do, they turn to the representative and say, okay, what would you advise? Because you're the one that the patient gave this authority to. You're the one the patient trusts the most.
Yeah, and it's been quite a while since the rep letter for me to be my dad's rep has been put together. And I don't even know if that really specifically covers like a DNR type of situation. And the other concern I have is, like, we've sort of come, not totally, but sort of through to the other side of the pandemic. But for a long time, nobody was allowed to go into emergency except the patient.
Yeah.
Right. So
So
if a patient
with the
can't talk,
representation agreement, they would still accept instructions over the phone. That was my experience during COVID, is that they would allow the representative to speak to the doctor over the phone, even though they wouldn't allow them in the room with the COVID issues. But with the representation agreement, it allows the representative to make any decisions in regards to personal and medical matters. So it includes a do not resuscitate. It's as close as we can get to do that do not resuscitate. It does not allow you, however, to decide to end life premature. So whereas certain people can opt into medical assistance in dying, your representative cannot opt into the program on your behalf. They can say, don't do all heroic measures, but they cannot say, we want to end life.
Okay.
Yeah.
Now, further to the, how many copies of whatever is floating around type of a thing, one thing that I also learned in a different session is the green sleeve program or method, where there is a plastic, what would you call that? A thing that
the plastic folder. It's done by Fraser Health or by the fire department, I believe.
Fraser Health.
Yeah, Fraser Health and the fire department partnered together. And that's a good folder to keep in your home with all of your important documents to let people know, I've done these documents, these are the people I've appointed. It also, I believe it comes with a list where you can write down the medications that you're currently on, so that when first responders come, they know what medication you're on, so what they should or shouldn't give you.
No, the one that I received
through the fire department.
It did. I got it through a presentation given by Fraser Health, and it did not come with like a form where you list your medications, but it was I believe it was a sheet that said, here are things you may want to consider putting inside here.
Yeah.
And so my dad's medications and all that stuff, his doctor, my name, blah, 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 all is on there. But the key part of this, it's called the Green Sleeve Program, because it's a folder that folds in half. It's a plastic folder, and on the back is a magnet. And the idea is that the magnet goes so that this thing sits on your fridge. And the first thing that a paramedic is supposed to do when they walk in is go to your kitchen and see if you have one of those on there. So I guess in the case of the representation agreement supersedes the DNR form. Therefore, if you put a rep document in there and say, contact me, because the rep document doesn't have your phone number, doesn't have your contact information.
So what our office actually does is when you do a representation agreement with us, we give you a little card where we list who your representatives are and their phone numbers. So you would put that card in your green sleeve.
Well, I put the actual whole document, but my dad was just in emergency 2 weeks ago, and he said when the paramedics were done, they did not take the rep thing with them.
No, they shouldn't. They should not take the original.
But then how does somebody in emergency know?
So you take the document with you. The representative has to be the one that has the original document.
No, it wasn't original.
It was, don't put the original in the green sleeve, just put the card saying this is who you contact. And that way first responders know who to call so that the representative knows there's an emergency. I need to get the document and go meet at the hospital.
No, this was a photocopy of the original. Because I didn't have a card like you're describing. It's an excellent idea to give to your clients to put that in there. But they of course took the list of medication that I always keep up to date, because he's got like 8 things that he's on. And so they bring their laptop with them, the paramedics do, and then they type all that stuff right at his residence and what he's currently on, and then they take him to the hospital.
Yeah, absolutely. So that's a great comment. If people aren't aware of the Green Sleeve program, it's a fabulous program. Again, you can get a Green Sleeve free through Fraser Health, or I believe any fire station, because typically they end up being first responders a lot of the times. And just put your important documents or the important information about personal and medical matters in that green sleeve and put it somewhere that it will be seen. So first responders, paramedics know what to look at and get a little bit of information about you to make sure they're doing the right situations. I did hear, because I heard about the program through the fire department, and they said some people weren't comfortable putting the green sleeve on their fridge with all of their personal information. So they gave out little green stickers, dot stickers, and you would put a sticker on your fridge and a sticker on the drawer that you kept your green sleeve in. And so the paramedics, first responders know to look for either the green sleeve or the sticker to find the green sleeve. Yeah, but that's great comments. Thank you. I've got another message here in the chat. How does a medical order for scope of treatment, differ from a DNR order? So I would assume the medical order for scope of treatment would be in relation to what you do or do not want during that treatment. Whereas a DNR, do not resuscitate, is simply if something goes wrong, do I want you to do all heroic measures to try and bring me back to life? But I have to qualify this. I'm not a medical practitioner, so I don't know what the difference would be. But I would assume that the representation agreement essentially would be a good one to rely on in order for a loved one, a family member that you trust, to interpret your MOST or your DNR order for the doctor if there are any gray areas. But again, as long as you've got capacity, you are welcome to fill out any medical forms you see fit, how you see fit, and you should be confident that your doctors and nurses follow your instructions. The representative would just be who they go to if there's a gray area they're not sure how to interpret. The representative would be the person you would trust to make that interpretation if you're not able to.
As far as I know, the MOST form is the DNR form. DNR is just one term used on that form where either it's, do you want resuscitation or do you not? And I can't remember what MOST stands for. It is scope of,
they've got a medical order for scope of treatment.
Right. So scope of treatment means how much do you want us to help you if you're laying there on the table in emergency? Do you want us to resuscitate you, or if yes, then you got to fill out the rest of the form, because there's all these different areas that you have to make a decision of how far do you want them to go. So in my dad's case, because he says, don't resuscitate me, well, that ends the form, because there's nothing more that they're going to do.
Mhm. Thank you, Bridget. That was fabulous. There you
I
go.
learned that the
Answered
hard
your
way.
question. I'm sorry to hear that.
Yeah.
We have another question real quick with our last 2 minutes, asking when did the healthcare representation agreement come into law? It's been around for quite a while, although I would say that doctors and medical practitioners weren't really aware of the document until probably around 2012-ish, I believe. So it's been more popular in the last few years. And it's now, I'd say in the last probably 5 years, a lot of care communities have now required the representation agreements before they will let someone move in, because they want to know, who do I go to if you're not able to make these type of decisions?
Could I ask a question, just a quick one?
Yeah.
When you're choosing a executor or a representative, what's your recommendation with regard to whether you should have children or outside persons?
Yeah, that's a great question, and it's different for everybody depending on your circumstances. I normally say name someone that knows you the best, that you would trust with these personal decisions, because they are very personal. If you know one of your children is very hard-lined, that you need to move into a care home and you don't want to move into a care home, I would suggest don't name that child, because if you lose capacity, you won't be able to oversee to make sure they're following through with your wishes. So it's definitely someone that you need to trust will carry out your wishes and your expectations to the best of their ability. Any other questions?
That's perfect timing.
This has been very informative. Thank you.
You are very welcome. It's been a pleasure chatting with you all. And I'm happy to chat further if you need help updating your documents. Feel free to reach out.
Yes, thank you, Eryn. I'll also be sending a follow-up email, and I can include Erin's email in there if you have any questions for her moving forward. And our next webinar series will be on June 7th. It'll be on advanced care planning with Fraser Health. So if you want to sign up for that, you can also just shoot me an email as well. Anyways, thank you everyone for joining us, and thank you, Eryn, and have a good rest of your day.
Thank you, everyone.